there's a problem with the audio on my side. One of the great things about Jason, I've gotten to see how he's worked with a number of different entrepreneurs across the world that have come through our network. And real happy to have him here today, just because, you know, in working with attorneys over the last 25 years as an entrepreneur, I mean, in my case, very few attorneys tend to make it easy. I mean, because you usually have like whatever the problem at hand is. And one of the things I really like about Jason, especially in the issue of immigration, as we're working on building businesses across borders and stuff like that, a lot of times, you know, whatever the issue is not simple in the first place. And so to have an attorney that actually working with you is that makes it easy. You know, his process is and his style is very, very approachable. I'm real excited about that. Thank you today, Jason, for joining us and leading this. And, you know, as we're building bridges around the world, in fact, I already seen we have entrepreneurs from Canada, New Zealand, and Mexico. I know, at least based on the names that I recognize. So I'm real excited to have you here today. So thank you for your input, and thank you for going out of your way to make it easy on entrepreneurs like us to go through these different issues that we have to do when we're building our business. So with that, I'm just going to be listening in on the backside. I appreciate, Jason, you know, your long-term commitment.
Oh, thanks. Truly, I'm flattered, both Kevin and Maria, for those comments, and it's my greatest pleasure to be doing this today and to speaking to all of you who may be watching this live or later. Look, I come from a family of immigrants. I know the challenges faced by so many of you to come here to bring your talents to this country, and the challenges you face. And so the least I can do is try to make this easy to understand. So again, flattered for those comments, and thank you so much for having me out, for Tech Ranch, and for all that Tech Ranch does for helping entrepreneurs and international startups to come to this country. So, you know, as Maria said, sort of the focus of my practice is mostly on employment-based and family-based immigration. And a lot of that is helping international entrepreneurs and startups navigate the U.S. immigration system, which you'll see is a bit complex, but we're going to try to make easy for you to understand. But helping people come here and launch their businesses and get the visas to do that, as well as obtain lawful permanent residence or green cards and citizenship. We're going to try to cover a ton of information here in a short period of time. I expect that most of you are going to have questions as we go through this. I'll leave some time at the end for some Q&A, and hopefully Kevin and Maria, you can help kind of navigate that, or people can turn on their microphones and ask questions. But you have my contact information there, and it'll be there at the end if anyone has more specific questions that they want to talk about when we're done. But again, the focus of this presentation is really on how entrepreneurs and startups can navigate the U.S. immigration landscape. And as I'm sure most of you hear in the news, so much is changing really on a day-to-day basis regarding immigration policies here in the U.S. So what we talk about today is the most current, recent information and practical information for you. But that's not to say these policies could be changing next week or next month or next year. But that's the sort of nature of what we're dealing with this current administration, which is really, in my opinion, trying to make the immigration process for talented entrepreneurs and startups as challenging as possible, so that some of you may say, "Ah, forget this, I'll take my talents elsewhere." But I'm here to say that that's not to say that doors are closed, despite what you may hear on the news, or that it's impossible to get visas to come here. No, it's quite the opposite. It's the same as it's always been. And one of the things I tell people, first off, when I'm talking about the entrepreneur and startup immigration landscape, is the U.S. immigration laws in this country are very, very archaic. They're very old-fashioned. So as we go through this conversation, I fully expect most of you will be saying, oh, come on, give me a break. How could this be? How could these rules be what they are? And you're right, it is ridiculous. But the U.S. immigration laws that are in place today really were promulgated in the early 90s. So before the internet took off, before globalization took off, before the jobs and job sectors that exist today in 2019 were in existence. So some of this may seem silly or some of it may seem ridiculous, but it is the reality. And it's sort of the nature of what we're dealing with. So that out of the way, I want to jump in first and sort of talk about the elephant in the room, which is what's going on right now with this current president and the sort of immigration landscape. In April 2017, the president initiated a immigration policy memorandum called Buy American, Hire American. Now, for many of the international people that are on this webinar, the president does not have the power to change U.S. immigration laws, despite what we may hear in the news. It takes an act of Congress to change immigration laws, which is why we have these stale immigration laws as they exist today, because Congress really doesn't want to touch that political issue. But what the president has in his very limited power is the ability to enact policies around these stale immigration laws. And what he did in April 2017 was issue this policy called Buy American, Hire American, which essentially said, look, I, as president, don't have the power to change U.S. immigration laws, but in my limited power, I have the ability to instruct all branches of the Department of Homeland Security, U.S. Citizenship and Immigration Services, USCIS, the body that adjudicates these applications, or consulates abroad, or Customs and Border Protection, the guys at the airport. I want all of you guys to do whatever you can to be as strict as you can in the adjudication of any single immigration benefit to make sure we're, quote unquote, protecting American security and American jobs. So what we have seen over the past 2 years is really strict adjudication of immigration benefits, especially for entrepreneurs and startups. So while many of you on the webinar may have spoken to friends or colleagues that say, oh man, in 2015 or 2016, we got, this particular visa or that particular visa was a piece of cake, no problem. It's a different environment today than it was back then. Again, not impossible, but just more strict than it was several years ago. We're seeing increased visa scrutiny. So as we go through this conversation, you'll hear me talk about some of the specifics that are required in getting some of these visas. And they may seem silly or ridiculous to you, but it's what we're seeing these immigration bodies that are adjudicating visas asking for, because we're seeing them being really, really strict in the adjudication, again, especially for entrepreneurs and international startups in getting these visas. And then there's also this increased focus on enforcement and compliance. And what that means from a more practical standpoint is there's bodies here in the US that are coming and knocking on doors when you're here in the US, verifying that you are where you say you are, you're working where you say you're working, and you're not sort of involved in other projects. The immigration process, especially for entrepreneurs and startups, requires you to be working for a particular business, and that's the one petitioning for you. One of the questions I get is, oh man, I came here, I got involved with Tech Ranch. Oh my God, I'm meeting all these amazing, awesome entrepreneurs in Austin or San Francisco or New York or wherever. And now I want to get involved with this side project. Unfortunately, the way this immigration system is when you're here working for a specific employer, you are tied to only working for that employer. And we're seeing increased enforcement in how they're coming to check up on those things. Just quickly, some of the policies we think are coming down the pipeline, especially for high-skilled immigrants. There's policies that are coming out to request additional information before approving applications. Again, more increased scrutiny and enforcement in some of those visa categories. This is where you're hearing the things about extreme vetting, and you're hearing these sort of horror stories of entrepreneurs and startups coming to the ports of entry and they're saying, you know, open up your cell phone, let me read your email, let me look at your social media. These are the types of things we're starting to see more often, not from a, oh, are you saying bad things about the president or the US government, but more about, let me see what type of work you're actually doing, because like I said before, you're only authorized to work for this specific employer or this specific startup. We're seeing for entrepreneurs and startups, even more stricter enforcement in the adjudication of those benefits. As I said before, these immigration laws in existence today in 2019 were promulgated in the early 90s. So way before startup culture, quote unquote, as it exists today in 2019 was in existence. So one tactic they're using to enforce these immigration laws is forcing nimble and agile startups and entrepreneurs into the sort of old-fashioned, you know, punch card, show me that you go to work, that you go to a particular office place, that you're sitting at a desk, that what tools are you using for your business. That's kind of the ways they're enforcing this. You may have heard back in 2016 under the prior US president, before he left office, he proposed a policy called the International Entrepreneur Rule. And really quickly, the International Entrepreneur Rule wasn't a visa, and it wasn't a pathway for people to come here and obtain status. But under that president, he said, look, in my limited power, I want to offer up what's called a work authorization card, a document, a physical card that would allow certain entrepreneurs to come to the US to work on a very temporary basis for their startups if they raised a certain amount of capital, if they were going to create a certain amount of US jobs. The current president, Trump, came into power and he did away with that rule. So one of the questions I usually get is, oh, hey, Jason, I've heard so much about this international entrepreneur rule. At this point in time, that's kind of dead in the water and not an option. It was never really, in my personal opinion, a very useful option for people who are looking to really kind of grow their businesses. But I kind of want to quash that real quickly because that's a question I usually get off the top. So now let's get into the meat of the conversation of what are the actual options? What can I do and come here to grow my business as a foreign national entrepreneur? These are the sort of questions I get most. The first is, are there restrictions to starting a U.S. business? Now, first and foremost, no. To actually start a U.S. business, you do not need a visa to do that. To create a U.S. corporation or LLC, or to even get a U.S. bank account for your business or a federal employer identification number. No one needs a visa to do that. The real question, though, comes down to whether or not you can work for your business. And the simple definition for what work is for immigration purposes is anything that a normal person would get paid to do, regardless of whether you're being paid, how you're being paid, or where you're being paid. When anyone comes here and engages in work, per the definition I just gave you, U.S. Citizenship and Immigration Services, or the Customs and Border Protection officers at the airport, or the individuals at consulates abroad, say one needs a work authorized visa to come here. There are many different types of what are called non-immigrant temporary work visas. They range from letters A to letters U. Each one of those letters has different eligibility requirements. Some of those letters do not provide for work authorization. We'll talk about some of them do. For purposes of this conversation, we're not going to be talking about every single letter in that alphabet because for the vast majority of people, those letters have no application. We're only going to be talking about a handful of those that are most commonly used by entrepreneurs and startups. But going back to that first question, yeah, you can register a business here, you can create a business, but whether you're coming here to work for that business is something that requires a foreign national to obtain a work authorized visa to come here and work for it. can you sponsor yourself for a U.S. visa? Generally speaking, the U.S. immigration system and that non-immigrant visa system does not allow for a foreign national to sponsor themselves. So the question I get is, well, then how do I do this? I need a U.S. employer to sponsor me? Yes, you do by and large, but there's ways for you owning your U.S. company to have your U.S. employer sponsor you. And we'll talk about that here in these slides coming up. As I talked about before, the difference between employment versus not employment is absolutely critical. It's one of the most hot button issues right now in the world of international entrepreneurs and startups. Again, the situation I see, and it's happening maybe every single week to the international entrepreneurs and startups that I work with, is them coming up to a consulate or a port of entry and an officer saying, hey, what is it that you're coming here to do? And they're saying, no, I'm coming here to, do some work for my startup, or I'm coming to do some software development for this company that I'm looking to work for. And when the immigration officer says, well, you don't have a work authorized visa, and the person says, oh, but I'm not getting paid, or, oh, this company is paying my company outside the US, or I'm a third party contractor, immigration officers are going, stop. You're telling me you're coming here to do software development or to, do certain activities. Does a normal person get paid to do those activities? And if the answer is yes, at the sole discretion of that immigration officer, you're going to be denied entry into the US or denied your visa category, okay? Now, most of you probably on this call, or those that are considering coming to the US, will usually start your immigration journey with either a B1 visa or coming with what's called a visa waiver. The B1 visa is an actual visa that allows foreign nationals to come to this country for up to 6 months at a time to engage in what I call not work activities, and we'll define those here in a little bit. And the visa waiver program is for certain foreign nationals from certain countries that are, in simple terms, sort of friendly with the US, that allows them to forego actually getting a visa and come under this visa waiver. Some of you may know it as the ESTA program, for up to 90 days at a time to engage in, certain activities of which there's you're not actually engaged in employment. So, the question of whether the activities you perform for your startup are activities that are work, again, as I said, are usually activities that someone would say a normal person would get paid to do. The question is then, what can I do on my B1 tourist for business purpose visa or my visa waiver when I'm here trying to start up my company? So again, owning or just starting a business alone does not constitute work or employment. So coming here to say, hey, I want to come and look at incorporating my US business, or conduct market research, or come and speak to investors, or raise money through presentations, or negotiate with angel investors or VCs, or talk to lawyers. All of these are considered not work activities. They're considered sort of passive activities and are specifically allowed on a B1 visa or a visa waiver program. So for those, number one, that already have either a B1 or a visa waiver and are coming to the US, you really want to focus on outlining those activities that are not work activities. Those that are thinking about applying for a B1 visa or are thinking about coming to the US on a visa waiver, it's really important you outline, what you're coming to do. If you're an entrepreneur and you're saying, hey, I want to come here and conduct market research and, develop a business idea, or look at locations for my business, talk to financial and planners, accountant experts, set up my entity, enter into certain agreements. Again, those are allowed, but you want to be really, really careful, especially in this tight immigration environment, because this is the scenario where we're seeing people, if you don't answer those questions correctly, officers at airports saying, hey, open up your phone. Let me read your email. Let me read your text message. Let me see your social media to see what it is you're coming to do. And if I, immigration officer, at my sole discretion, think that you're engaged in work, I'm not going to let you in. The other important wrinkle to this, these are all temporary visas. And whether you're applying for the visa or coming to the visa at the port of entry, you're going to need to prove that you have an intent to return to your home country. All of these visas we're going to be talking about, built into them is what's called non-immigrant intent, meaning you, the foreign national, have to show you're going back to your home country at the end of your temporary stay. It's not enough to simply say, oh yeah, no, I'm going back, or here's my return ticket. Right now, we're seeing immigration officers saying, prove it. Do you have a house title? Do you have an apartment lease? Do you have a car deed? Do you have bank accounts? Do you have a letter from your job over there? Do you have family back in your home country? Tax returns? Really, there's infinite ways to prove it, but you're going to have to prove that you intend to go back with actual evidence. And for those that say, hey, Jason, can I just come on the B1 for 6 months or the visa waiver for 3 months and then go back for a week and try to come back again? Yeah, that may work the first time, but again, the current trend we're seeing, especially for entrepreneurs and startups that are trying to grow their business and need to come to the US often, eventually officers are going to say, hey, wait a second, this is the third time you're coming for 90 days or 6 months in a calendar year. I don't really think you have the intent to go back to your home country, or I think you're working here in the US. So you want to give yourself some time in between visits before coming back to avoid those issues of your non-immigrant intent. Okay, so now I want to get into really the work authorized visas that most entrepreneurs and international startups are utilizing to come here on a sort of long-term temporary basis to grow their business. And probably the most versatile and popular visa that entrepreneurs and foreign nationals are using is the L1A visa. The L1A visa is called the intra-company transferee visa. Most notably, this visa is used for multinational companies that are moving executives and managers back and forth between foreign-related entities in the US. Think of the AT&Ts and the Coca-Colas and the big multinational corporations. But for international entrepreneurs and startups, there's a provision called the New Office L1A visa. And the New Office L1A visa works like this. You, the foreign national, have to first show that you have worked for a foreign company anywhere outside the US for 1 full year in an executive or managerial capacity, meaning you are on a company payroll for your foreign entity, and you have 12 months of paycheck stubs, and you've been working in an executive or managerial capacity, not necessarily by title, but by the activities you're performing. You can demonstrate, you have other employees underneath you that you're managing, and that you're performing executive or managerial functions. If you can prove with 12 months of paycheck stubs that you've been working for that foreign entity, you can then create a new related US entity, a subsidiary, parent, affiliate, branch entity of your foreign company. You'd get a bank account here in the US, you'd get, an office space, and you would make a petition for an L1A visa with USCIS to ask for 1 year of an L1A visa. Essentially, you'd say, hey, look, I'm coming to start a new business here in the US. I don't yet have any ongoing business activity. I don't yet have any employees, but I've got a business. I've got bank accounts. I've got office space. I've got a business plan that shows this is a reasonable business that can grow. You would ask USCIS for an L1A visa for 1 year. If USCIS approves that L1A visa, you can apply thereafter in 3 2-year increments. So 3 times in 2-year increments for extensions of that L1A visa up to 7 years. But the biggest challenge faced by entrepreneurs and startups in this L1A visa category is showing that you've actually grown that business after your first year, or really before that first year when you go to apply to extend that visa. You're going to have to show that, you know, the business has employees, that there's ongoing business activities. The business doesn't actually have to be making money, but you're going to have to show that, you know, you didn't just come here and hang out, that there's actual activity going on in the business. There's no minimum investment required for an L1, but you have to show, you know, that there's enough activity that it can support you coming to the US to work in an executive capacity. This is a versatile visa for foreign nationals, and especially for family members, for foreign spouses that can come here and get an L2 visa, and they can work on or apply for a separate card that would allow them work authorization on an L2 visa. And it's a sort of versatile visa to obtaining permanent residency in the long term, if that's something of a consideration for anyone wanting to be here long term. The next visa category is called the E1 and E2 treaty trader or treaty investor. The E1 is for treaty traders. E2 is for treaty investors. This visa category is for foreign nationals from only certain countries that have a treaty with the US. So here's where I sort of get to burst the bubble for many of you on the webinar or watching. Currently, countries that do not have a treaty with the US and are not eligible either for the E1 or E2, China, Brazil, India, Russia, a whole host of other countries. Those are just some big ones. You can Google E1 and E2 countries to see if your country qualifies for the E1 or E2. But if it does, under the E1 category, if you as a foreign national are engaging in substantial trade between the US and your country of nationality, meaning at least 50% of the trade is happening between your country and the US, you can get an E1 visa. Under the E2 category, if you're coming to make a quote unquote substantial investment in a US entity that you're going to run, you can come here and get an E2 visa. The first question I usually get on that is, well, Jason, what is a substantial investment? It used to be, well, I guess it still is, but it used to focus much more on the type of business you were coming to run and whether the investment was proportional to the type of business you were going to run. So, you know, if you were coming here to start in Austin, we have, you know, lots of food trailer trucks. So if you were coming to start a food trailer truck business, okay, the investment was probably going to be a lot less lower than if you were going to come start a semiconductor fabrication facility, you know, much higher. That said, and this is sort of arbitrary, but the trend we see right now in the E2 category really is the closer you as a foreign national are investing to about $100,000 US, the more US or the Customs and Border Protection and the consulate officers will consider that to be substantial. They'll say, hey, we think this is enough to get your business running, to get your office, to get your equipment, to get your employees, to pay for your utilities, so on and so forth. That's not to say it has to be $100,000, but the more, at least in my experience and my colleagues, the more a person invests, you know, closer to that, the stronger your case is. Again, with any of these categories, you know, this is the E2 requires providing a really substantial business plan to show how your business is going to grow. Additionally, that investment that you're going to make before you get the visa, the consulates want to see that the majority of that, let's call it $100,000 or whatever your investment is, has already been invested in the business before you even before you get the visa itself. Additionally, they want to see that this is a business that's not going to just provide for you and your family. They want to see that this is an investment that's going to create opportunities for local workers. So again, before you get the visa, they want to see that the company has actually hired U.S. employees. It doesn't require a ton, could be 1, 2, 3, but it's got to be some employees in the company that are hired as full-time employees in the U.S. before they would issue the E2 visa. So yeah, that's generally the E1, E2. Next category. This is more for those individuals that are looking to come and really be an employee of a company. Generally, the H-1B is off limits to individual entrepreneurs who are looking to self-sponsor themselves, because USCIS requires that a petition employer demonstrate that it has the right to control, including hiring and firing a foreign national employee. And that's difficult to prove when an entrepreneur is the owner of the company or has a controlling interest in the company. You know, it used to be, as in, you know, several years ago, that, you know, if you structured a company's corporate governance in a way to allow, you know, a board or a similar entity to exercise control over an entrepreneur as an employee, that might work for H-1B visa purposes. But right now, that's just, they're coming down really, really strict in this visa category on people trying to abuse that. So, you know, typically for an H-1B visa, you're going to have a U.S. employer who's sponsoring you in a job that at a minimum requires a bachelor's degree to perform. And that whether or not a job requires a bachelor's degree is really defined by the U.S. Department of Labor. And that you, the foreign national, have a bachelor's degree that relates to the position you're going to be working in. The H-1B visa category is the only non-immigrant visa category that we'll talk about in this presentation that has a cap, a limit on the amount of visas that are issued each year. That number is 85,000. So each year on April 1st, U.S. Citizenship and Immigration Services makes 85,000 H-1B visas available for everyone in the world to apply for. If that visa gets approved, it becomes active to use on October 1st. So applying on April 1st, if it gets approved, it's active starting October 1st. It's good for 3 years initially, plus a 3-year extension thereafter for a maximum of 6 years. But the problem with this visa category is that each year on April 1st, at least in the last 6 or 7 years, USCIS receives in excess of 85,000 H-1B visa applications. Literally on April 1st, they tell employers, okay, we're not going to accept any more H-1B visa applications this year. We're going to take all those that we received on, you know, the first few days of April and put them in a computer-generated lottery system. And we're going to let a computer select at random the 85,000 that will then hand process to see if they're approved. If the petition is not selected in that lottery, it's sent back to the employer. Sorry, try again another year. If it is approved, again, it becomes active to use on October 1st. So, you know, this is for those that truly are entrepreneurial and truly want to sort of run their own business. This isn't really a great option. But I sort of talk about this here for those that say, hey, you know, I met someone here who's willing to, I'm willing to give ownership of the company to, and they'll hire me as an employee, but they'll, control me as an employee. You know, we'll have an employment contract that says in the traditional sense, when I can come to work and when I can take vacation and when I can go to lunch and what I can wear and all those, you know, sort of old school things. And he'll apply for me. Yeah, that's a category that can work. I'm sitting here literally looking at a stack that's as tall as I am, and I'm nearly 6 feet tall, of H-1B visa applications, because we're here at this year's sort of finish line that are going in at the end of this week. So, you know, the H-1B visa is not even really a consideration for 2019, but something to put in the back of your mind for 2020, April 2020. If you consider this an option for employers or someone that, you know, you want to give up ownership or control of and consider an H-1B visa. Real briefly, because I want to give some time here for some questions. Other non-immigrant visa categories, all of these, by the way, require a U.S. employer to sponsor you. They don't allow for self-sponsorship. The O1 is for foreign nationals of extraordinary ability in certain fields. If you have an employer that wants to sponsor you based on you reaching the top of your field, as demonstrated by you winning major awards in your field, you being published in major media, journals, television, newspapers, radio, you speaking at major conferences in your field, you judging the work of others in your field, you working for prestigious organizations, the O1 could be a category. The TN is a visa only for Mexican and Canadian foreign nationals working in certain occupations. Again, this does require a U.S. employer to sponsor you. The occupational categories, you can Google them. They're very, very old school occupational categories like doctor, lawyer, teacher. There are some categories that are a little more flexible for, management consultants and, certain types of computer fields. But those categories are highly, highly scrutinized right now because there's a lot of abuse in the TN category. Again, it's a question of if you find a U.S. employer and you're Mexican or Canadian looking at one of these fields and you think you can qualify, it's worth a debate or worth a discussion to debate whether or not you can meet the eligibility requirements for that. Again, none of these visa categories have caps on them or any time of year in which you can apply. You can apply for any of these. And for anyone who's on the webinar or watching later, if you're an Australian foreign national, the E3 is kind of like the H-1B visa category we talked about, but only for Australian nationals, meaning that you're working for an employer in a job that requires a bachelor's degree and that you, the Australian national, have a bachelor's degree that relates to that position. Finally here, sort of just a very brief overview. Everything we've talked about are all what are called non-immigrant temporary visas to the U.S. They provide only temporary work authorization. But if you're here, especially in the L1A category or the H-1B, and in some cases the E category, and business goes great and you're hiring employees and you're growing your entity, you may want to consider U.S. permanent residency as a sort of long-term option. There's several pathways to obtaining permanent residency, meaning you can reside in the U.S. permanently. The first being family-based, which is, if you marry a U.S. citizen or a U.S. lawful permanent resident, you may be able to obtain lawful permanent residence that way. Under the employment-based category, sort of simply put, the U.S. government says, look, it's one thing if you, the foreign entrepreneur or startup, want to come here and start your business on one of these temporary non-immigrant visas because, hey, you know what? You're telling us you're going to go back to your home country at the end of 3, 4, 5, 6, 7, 10 years, whatever it is, that's fine. But if you want to be here permanently, the U.S. government goes, well, wait a second, we've got American jobs we have to protect here. So we, the U.S. government, are going to make your U.S. employer go through a test of the U.S. labor market to prove to us, the U.S. government, that there are no qualified, able, willing, or available U.S. workers who can do what you, the foreign national, does. And that oftentimes requires a long and expensive, active recruitment campaign where your employer is posting ads in radio and television and newspapers and online to actively recruit for an American worker who can do what you do. And if they, can't find that person, then they can go through a multi-phase, multi-year-long process to get you permanent residency. Now, the L1A category for those entrepreneurs, and the reason why I say lots of the clients I work with utilize that L1A category, is there is a sort of exception to this rule, and there's a category for executives and managers that are looking to have their U.S. entity sponsor them as an executive or manager to bypass that recruitment of American workers. And in some instances, get a faster pathway to permanent residency. So oftentimes, people who are here on the L1A, they're an executive, they're CEO of their company, they've grown it, and now they've got, several US full-time employees. The business is grown, they've got bigger office space. We can look at developing a pathway to permanent residency for them through them being the CEO or a manager of their US entity. Finally, under the EB5 category, currently, emphasis on the word currently, there is a program that allows foreign nationals who are investing personally, emphasis on the word personally, either $1 million into a US business that's going to create jobs for 10 US workers, or $500,000 into certain areas of high unemployment and certain projects where they'll pull the investment money at $500,000 of lots of foreign nationals together that are going to create jobs for 10 US workers. Either of those pathways are, or either of those two scenarios are pathways to permanent residency. They're long, they're not quick. Usually you're looking at, 3, 4, 5 years of sort of waiting time to get a green card or lawful permanent residence through those programs. High risk on the $1 million side. If, the economy tanks or the jobs aren't there, you've lost your money and you'll lose your green card. A little less risk on the $500,000 side because the sort of these projects have an interest in getting finished and keeping the jobs there. As I said earlier, those are currently the investment amounts. There is lots of talk that sometime this year, Congress will pass some legislation to increase those amounts. We don't know what they are. Our guess is that $1 million may go up to somewhere around 1.5 or 1.8. We're guessing that $500,000 could go up from anywhere to 1 million to 1.5 million. So I sort of throw that out there for any people that are kind of looking at making passive investments as a way to a green card. I sort of rush through that really quick because I know we've only got an hour and I want to give some time here to questions and open things up. This is my contact information here. So if anyone has questions that I didn't get to or want to discuss things further, you can reach out to me through here. So I'll open it up now for some questions if anyone has any.
Thank you so much, Jason.